It's an ambush.
Oh my God, it's an ambush!
It's an ambush!
Of course!
Good morning, everyone, and welcome to a insomnia stream, but hopefully something productive-ish. There's no plan for this. It's not going to be very fancy. I'm doing this mainly for informational purposes for myself, maybe for you. So back in 2022, fall thereof, there were the oral arguments for the affirmative action case that has become so significant in the anti-DEI movement, such as it is now. And a case, oral arguments before the Supreme Court were heard yesterday concerning a case that is related in a way, because it has to do with Title VII. And Title VII is the part of the Civil Rights Act of 1964 that I feel has very often and very blatantly been violated by many companies that employ DEI practices. So I didn't get a chance to listen to the oral arguments yesterday because of work and stuff. And by the time I got to bedtime yesterday now, I was just kind of like, I'll listen to it tomorrow or something. Well, then, of course, I wake up at 2 a.m, can't get back to sleep. I got about an hour and a half or something until work time starts. So the oral arguments are only an hour long. And as far as I know, because they are the Supreme Court of the United States, the audio is copyright free. Fingers crossed, knock Formica. So I'm going to just let it long play. I may pause here and there if something occurs to me, but this is primarily for my own edification in lead up to whatever decision they eventually make on this case. But with all that as preamble, who's joining me? Good gravy. I didn't imagine anybody would be here. Attack Alpaca, good morning. Kiro Soldier, good morning. Zero the Hero 909, good morning. Mike Savage, Blarg. Shady Grin, good morning. Who else is here? The Blakester, good morning. Duck Dog, good morning. Angelverse, good morning. Good evening, Scribbles will watch this tomorrow. Well, it'll be here for you when you're ready. Okie Native, thank you so much. Oral arguments generally end them if she's cute. Thank you, Okie Native, very much. Appreciate it. Hope you're having a good morning so far. Scanner Daffley, good morning. Spoony the Rebel, good morning. So yeah, there's not going to be any sort of excitement here or action. There's just audio. There's no picture. Let me give you the very brief summary of what this case is about. Marlene Ames worked for the Ohio Department of Youth Services for more than 20 years. She claims that she was passed over for a promotion, then demoted because she is straight. The job that she had hoped to get and the one she held when demoted was both given to gay colleagues, according to the lawsuit. So her argument is that she is the victim of workplace discrimination, employment discrimination in opportunity on the basis of her orientation. Now, orientation, and this is coming from a non-lawyer. All right. Orientation under Title VII is technically not listed as one of those protected elements or classes. Sex is listed, so if you're a male or a female, those particular things are protected under the strict understanding of the law. But orientation, not explicitly, although it has been extended to effectively become a protected element over time and because of precedent. This may further clarify that depending on what the arguments are. Now, again, I haven't heard the arguments. I haven't read a summary of the arguments, so I don't know what's going to be happening here. So I'm just going to start playing. And if something occurs to me to pause, to comment on, then there you go. I'll keep an eye on the comments as well since I'm not watching a video. Also, good morning, Tall Person. And Daryl Odell, there's a 6 o'clock in the morning now. I know, right? It's cray-cray. Anyway, can't stay, have to get ready for work. Yeah, I do too, in about, an hour and a half or so. So I'm just going to let this run. And let's learn what the Supreme Court had to say on this and what the lawyers had to argue.
We will hear argument this morning in case number 23-1039, Ames versus the Ohio Department of Youth Services. Mr. Wang?
Mr. Chief Justice, and may it please the court. Marlene Ames has worked for the Ohio Department of Youth Services for over 2 decades. And in 2018, her year-end performance review described her as being very competent in her role, a pleasure to have on the team, and always willing to assist others. But in 2019, she experienced two adverse employment actions. First, she sought a promotion to bureau chief, for which she was qualified, for which she applied, and for which she interviewed. But neither she nor the two other heterosexual employees who applied and interviewed got the job.
Okay, so that's the first claim. The first element of the case is that everybody who applied but did not receive the job were heterosexual. Now, of course, the question would be, can Ames show that the people who were doing the employment decisions knew the orientation of all individuals involved and could conceivably have made a decision based on that knowledge? So I guess that would be sort of the primary question the linchpin of the case is, did the employer know the orientation of either the people that they decided not to hire versus the people that they decided to hire?
Instead, the job was held open for 8 months before going to a gay employee who neither applied nor interviewed for the position.
Oh, okay. Is that true? I didn't even want the job, but they gave me the job. Okay, that's a little suspicious.
And second, Ms. Ames lost the job that she was in, and she lost it and was replaced by a separate gay employee who also
Coincidence?
did not apply or interview for the position.
Oh.
Based on these facts, the Sixth Circuit held that Ms. Ames had satisfied the usual requirements for stating a prima facie case of discrimination under Title VII, but she could not proceed because of the background circumstances rule, which the Sixth Circuit described as an additional showing unique to majority group plaintiffs. The narrow question before the court today is whether this judge-made rule is consistent with Title VII, and we submit that it is not. It's not because this court has said that Title VII aims to eradicate all discrimination in the workplace. But the background circumstances rule doesn't do that. It doesn't eradicate discrimination. It instructs courts to practice it by sorting individuals into majority and minority groups based on their race, their sex, or their protected characteristic, and applying a categorical evidentiary presumption, not in favor of, but against the non-moving party, based solely on their being in a majority group.
Okay, this is getting to legalese. It's starting to hurt my head at this time of morning, but I'll keep going.
However you define it. But that's not consistent with the statute that tells us that we are supposed to protect all individuals from individual discrimination based on the individual case. And it's not consistent with McDonald versus Santa Fe Trail, where this court says that all individuals, whether in majority or minority groups, are protected by Title VII.
Okay, so this is I think if I'm hearing this correctly, this is the sort of reverse discrimination theory that you can't prove that the majority being discriminated against is actually a crime because they're in the majority, etc., something like that. But as anybody who can think for 3 seconds knows, there's no such thing as reverse discrimination or reverse racism or anything else. There's just discrimination. There's just racism. It's like saying black people can't be racist against white people because white people are in the majority and they hold all the power. No, you can be racist. You can be racist against your own race. Racism knows no bounds, and there's no justification for it on either direction, depending on the majority or minority of the population being targeted by said racism, by said discrimination, whatever. So I think that's what's happening here, or what's he's arguing against.
Under the same terms and the same standards. For these reasons, we urge the court to reverse the judgment of the Sixth Circuit. I welcome the court's questions.
What do you do with respondents' argument that this is merely an application of our precedents?
I don't think it is an application of this court's precedents, Your Honor. And Justice Thomas, it's because this court's precedents in McDonald Douglas lays out a framework, and then McDonald versus Santa Fe Trail says they apply to the same terms and same standards. But the background circumstances rule isn't the same term. It's not the same standard. The Sixth Circuit says it's an additional burden. And in prior cases, it says it's a difficult and more demanding burden on majority group plaintiffs. So I don't think it's consistent with this court's precedents.
What if you have a situation where, say, 60 employees in the company, say, a half dozen African Americans? An African American applies for a job. There's an opening. He doesn't get it. Remains open for a couple of months. Does that satisfy the prima facie case? And he said, it was because of discrimination.
Assuming that they are qualified and yes.
Okay. Now, I'm sorry, that's a yes?
Yes, that is true.
Okay. Now let's say it's the same thing, but the applicant is white. Exactly the same facts. And she says, I lost the job because of discrimination on the basis of race. Does that state a prima facie case?
I think it states a prima facie case, but I think it goes, and perhaps, Your Honor, it goes to the idea of getting employers to come forward with an explanation and then providing sort of a legitimate non-discriminatory reason, which I don't think is a high burden at all. I think as Reeves, as Burdine, as Franco made clear, they just have to provide some sort of legitimate non-discriminatory reason to answer or to rebut the prima facie case.
Yeah, legalese left, right, and center. Let's see. No, it's the lack of interviews. Well, yeah, that's the one part of this. If what the attorney is saying is true, that's the one part of this that makes it the most suspicious. Is that in both instances, both the job that she wanted and then the job that she had held, they didn't even interview these individuals for the job. They were just given the job sort of out of hand. Which is pretty suspicious. Now, whether or not that was a result of the orientation of the individuals, again, I guess it depends whether it was just a coincidence. Coincidences do happen, or if they can show that the employer knew the orientation of the two new hires, and as well knew the orientation of those who were rejected, and that there's some kind of evidence that was the decision point, not just the lack of experience here, there, and otherwise. Because I mean, if these guys were hired because they were the nephews of the boss or something, I mean, nepotism doesn't make it any better or something, but it might be a bit more difficult to prove under Title VII. So, yeah, that's my non-legal expert first blush reaction. Also, by the way, Gene Hackman is dead. What the hell is happening? Okay, that's a story for another day. We'll probably talk about it on Midnight's Edge tomorrow. But Gene Hackman and his wife and their dog were found dead. This breaking news sort of happened an hour ago or something, or broke an hour ago. They don't say anything about cause of death. I'm wondering if it wasn't like a carbon monoxide poisoning or something, but we'll find out, I suppose.
Can I just clarify the chief's hypo, though? In both situations, the job stays open for a few months, but then it is filled by a person of a different race. Is that right?
I was under the understanding, under the Chief Justice's hypothetical, it remained open.
It just remained open.
Yeah,
that's enough.
My understanding too.
That was my sorry.
Okay.
Sorry, and I'm happy to.
Sorry,
We can talk hypotheticals all day, guys. I mean, if you want to change the story here about this hypothetical we're talking about, not the case involved, it's fine. Okay, if you're not listening to what the other guy's saying, you're a Chief Justice, right?
Answer an alternative. Yeah. Sorry.
Okay.
Sorry about that. Yeah.
No. Well, what if it was changed according to
Oh my gosh, yeah, it is a comedy routine.
That's a fair question, and I
guess my point is that the standard, the test for prima facie case, at least as I understood it, maybe I'm misunderstanding it, is that you have to state circumstances that could give rise to a reason to believe that there is racial discrimination or discrimination of some sort. And so I would think that just saying I applied for a job and it remained open, I don't know, is that enough? Or do you have to say, and then it was filled by someone of another race, and that is what then gives rise to the inference of discrimination?
Well, it's the elements of the job remained open, even though there were, career tenured candidates looking for it. And then you gave it to people who didn't even apply for the job. I mean, keeping a job open because maybe you're looking for somebody from the outside, right? How many times have we seen, let's say, police chiefs or something where, a police chief is fired or resigns or something, and they decide, well, we need to shake things up. So we're going to try to go for a police chief replacement from outside the department, from a different state or a different jurisdiction or something, in order to have less conflict of interest, and are bringing new ideas and so on. So you could have, 5 or 6 people from within that department, that police department, applying to become chief of police. Maybe they've been there as long as the original chief of police, or, have more experience. But if the powers that be say, no, we want a different angle on this, keeping the job open in and of itself is not proof of discrimination against someone on the basis of their immutable elements. It could be just on the basis of, well, we're looking for somebody that's not, part of the status quo. And that would be an argument towards someone's merit. I guess the question here is, the element that really puts the poison pill in it, is that the people that they did give the jobs to didn't even interview and didn't even apply. So that adds another layer of what was the thinking here. If you had qualified long-term candidates in the queue and you decide to go with somebody who didn't even want the job versus people who did and had more experience. Yeah. So I either it's nepotism, it's like, this is my cousin's kid or something, or there's something else going on. So I guess I don't know the details of the case down to the nitty gritty. So I'm really curious to know, aside from suspicion, what evidence, testimony, communication, emails, or something else does the plaintiff have to show there was a decision point that involved active discrimination?
Well, let me try to unpack that in 2 ways. I think the first is whether, when it's filled by someone of the same group or a different race or something, I think that brings into the issue of whether there's a similarly situated comparator, which is a common analysis that takes place in most of, I think, the lower courts when it comes to stating a prima facie case. If it's held open, though, I think that means that the prima facie case serves as an explanation forcing mechanism. It's just meant to bring the employer to the table, as Hicks says, to come forward with some sort of explanation. It's not supposed to be a heavy burden on the employer. I think naturally, as this court has pointed out, often it just happens anyway in depositions or in other declarations. But it's just asking the employer to come forward, provide some sort of explanation in order to continue the process of understanding whether discrimination occurred. Justice Jackson.
I guess what I was just trying to get at, and I should have been clear that the position stays open, that in one case, I suppose, just because of the underlying facts, the assertion that this was discriminatory, it seems to me, is more plausible than the assertion that it was discriminatory if everybody else in the company is white as well. But you're saying that you can't take that fact into account.
I'm not saying you can't take the fact into account. What I'm saying is, with regard to the question presented, it becomes a categorical evidentiary presumption. I don't think that's fair. I think what we've said is that, look, these facts might give rise to a prima facie case of discrimination, and I think that the employer, of course, will come forward with a legitimate non-discriminatory reason. And then when it comes to pretext, when it comes to the ultimate question of discrimination, one, of course, looks at all the facts that's before them. The question, I think, that is presented here is whether there's an additional burden specifically on majority group plaintiffs. I don't think that's consistent with either Title VII's text or this court's precedent.
Yeah. So again, the burden is like, oh, well, can you be racist against the majority demographic? Can you be sexist against the majority demographic? I think is the thing. Can you show that? My, and I know this might be a little bit of a biased question. Does the Ohio Department of Youth Services have a DEI program or a DEI policy? I mean, just out of morbid curiosity. Let's see. Well, I don't see anything off the cuff that says anything like that. But yeah, that would be the question. But yeah, this is the kind of thing that if there are going to be lawsuits against companies for DEI decisions, this is the kind of question and kind of burden that's going to come up in a lot of cases, because having a DEI, like if you have an HP, for example, and you have footage of one of their executives saying in no uncertain terms that they have a hiring quota that they've set up based on the population demographics of the country, but they want to exceed them. And also that the chief information officer in his own office makes sure he has a balanced number of men and women on his team, which already sets up a 50-50 quota by blatantly saying so. You might have at least the starting point to make a claim that this company practices a quota system and is actively discriminatory in their hiring practices and promotion practices. In the Ohio case here that we're listening to, again, you need, just because it walks like a duck and sounds like a duck, etc., doesn't necessarily mean you can say it's a duck unless you have something tangible. And by tangible, I'm talking about like an email from a supervisor saying, we're going to go with this person because they're gay, or we have too many straight people in the office, something like that. Some statement from the organization of intent, or something that implies that this was the decision point. Because you need that. And I'm waiting to see, aside from, it doesn't look good. I mean, it looks kind of stupid. You have career professionals with 20 years experience ready to take on this more supervisory job. And then she gets passed over for someone who is less experienced and also never applied and was never interviewed for the job. Seems suspicious. Is it because that they are gay? Is it because she was discriminated against because she's straight? Was she denied an opportunity based on an immutable element of her makeup rather than something dealing with her experience or otherwise? If the supervisor decided to go with somebody less competent because they could pay them less, well, that's stupid on their part, and it may be discriminatory after a fashion, but it'd be a lot harder to prove under Title VII, which deals with fairly immutable elements, save for maybe religion, because people can change religions, but that kind of thing. Anyway, you know what I mean.
Counsel, what do you have to say to the department's contention that this is just going to throw the door wide open to Title VII suits? Because
well, honestly, I hope the door is thrown wide open to Title VII suits if you have evidence for it, and there should be, especially under the pall that has dropped over our country in the last 10 years because of DEI and DEI philosophy. Oh no, this will open up the door to more people arguing for their civil rights. Heaven forfend. Okie native, thank you again. If it walks like a duck, etc., it's probably a furry. It could be. It could be just a very elaborate costume for a con or something. Thank you, Okie native. Appreciate it again. Dom O'Leary, good morning. Jaeger Pony, good morning. Scrappy, good morning. Who else did I miss? John Hammond, good morning. Or sorry, Josh Hammond, John Hammond. Josh Hammond, good morning. Digi, good morning. Hope you'll forgive me. My brain is still not completely woken up yet. Well, yeah, okay, so yeah, what if?
now everybody can say, hey, this was discrimination on the basis of race, gender, et cetera.
Well, if you've got some evidence of it, yeah, you can scream discrimination, but again, sometimes it's difficult to tell without some backup evidence. So does Ames have evidence beyond the appearance of impropriety?
Well, I don't think that contention is well taken, Justice Barrett, and for two reasons. The first is this is an evidentiary question that arises at summary judgment. So they've already gotten past a discussion with the EEOC, plausibility under Iqbal and Twombly, a motion to dismiss. So I think if there were a floodgate issue, that would be sort of more on the pleading standards. I think the second point is merely sort of an empirical question. And as we lay out, and as Judge Kethledge lays out in his concurrence, about more than half the circuits don't apply the background circumstances rule. We don't see those circuits having some sort of flood of litigation. I don't think there's a huge delta between those circuits that apply it and those circuits that don't apply it, which I think goes to the narrow question that's before the court today.
Okay, again, more legalese. It's one of those things where like you listen to somebody talk and you get the gist, but it's difficult to then re-articulate it back. It's like listening to Shakespeare. You kind of understand what's going on, even if the language being used is a little bit outside your ken. Jill Powers, the River Daughter, good morning. I'm lurking and listening while I get a roast dressed. Ooh, roast beast. Oh man, I could go for some roast beast right now.
In the circuits that don't apply it, I guess I was a little bit unclear about one of the points that you made to the Chief Justice. In the circuits that don't apply it, you said the fact of a particular person's particular race or whatever it is, gender or sexual orientation, can come into account as a circumstance. What did you mean by that?
Yeah, I'm not sure. If I was a little bit unclear, let me try to clean that up a bit. I think what I meant is in the circuits that don't apply it, they, as the Third Circuit and the 11th Circuit lay out, they just take the McDonnell-Douglas standard and they say, well, what sort of protected characteristic are you talking about? Is it adverse? Are you qualified? And did the job remain open or did you fill it with a similarly situated comparator? I think the question of, well, context mattering, I think that often comes in at steps 2 and 3. It comes in once the employer comes forward, after you've settled the most common non-discriminatory reasons. Once the employer comes forward with the explanation, then of course that becomes more case specific. And you talk about hiring patterns at the company, the makeup of the company. I think that of course all comes into play. And I think that comes into play in many of the lower courts.
Mr. Wang, I'm going to ask you an unfair question. This case is proceeded on assumption that McDonnell-Douglas applies at the summary judgment stage. Yet this court has never held that it applies at the summary judgment stage. What should we do or think about that?
Well, Justice Gorsuch, I'm going to try to give you a fair answer to that question. And my sense is that all the parties here take McDonnell-Douglas sort of as a given. And I think the first level response I'd have is, because we take it as a given, we're trying to focus just on this narrow question of whether this add-on to McDonnell-Douglas in the common cases is appropriate.
Okay, I don't know what I've heard McDonnell-Douglas being referenced before in Title VII instances. I don't know. Let's find out. McDonnell-Douglas Title VII. Let's see. The burden shifting in United States employment discrimination law, McDonnell-Douglas burden shifting, or the McDonnell-Douglas burden shifting framework, refers to the procedure for adjudicating a motion for summary judgment under a Title VII disparate treatment claim, in particular a, quote, private non-class action challenging employment discrimination, unquote, that lacks direct evidence of discrimination. It was introduced by the United States Supreme Court in McDonnell-Douglas v. Green and Texas Department of Community Affairs v. Burdine, and has been elaborated on in subsequent cases. The McDonnell-Douglas framework is typically used when a case lacks direct evidence of discrimination. In other cases, courts may decide not to use the McDonnell-Douglas framework and instead evaluate disparate treatment claims under the Price-Waterhouse mixed motive framework. Okay, so it's a matter of approaching a claim of discrimination in the absence of direct evidence. So effectively, you're trying to say that there's enough smoke to suggest there's a fire without actually seeing the fire. So that's the argument that they seem to be making here, as far as I understand it, is that there's too many elements that suggest that the Ames was discriminated against on the basis of her orientation because of the common elements of the individuals who then replaced her own job as well as the job that she filled the job that she was looking for. So I guess the one thing I would need to know as well is there evidence, not necessarily, I think I said this earlier, not necessarily of active discrimination, because that could be hard to find. Is there evidence that the employer at least knew the orientation of all individuals involved? Because if there's not even evidence of that, then it's going to be even harder to show that there was an active decision made to distinguish between them on the basis of their orientation. And I realize that's evidence that it's not necessarily evidence that they did something wrong, but they would at least have to show that the knowledge of the orientation of the individuals involved was available to the decision makers, I would think. Otherwise, how thin does the gruel have to be, so to speak, in order to get a case adjudicated in favor of a plaintiff in a McDonnell-Douglas framework. I'm trying to sound smart. I don't know if I'm succeeding. You let me know.
So that's the first one. I think the second one is because the parties sort of take it as a given, it's not really the best vehicle to really re-examine it. Of course, as Donna points out, there is another case that's pending before this court that could be granted that re-examines it. But I think maybe as a final point, whether you have McDonnell-Douglas or not, there's still sort of this underlying question of, should you apply some sort of categorical evidentiary presumption against an individual based on being in a majority group? And I think the court's opinion in Bostock says the answer should be no.
That's why it was an unfair question, because nobody's asked us to do anything about it in this case. And I appreciate that, but you're standing at the podium, so what the heck, right?
Every justice is a comedian, apparently.
McDonnell Douglas was devised back when there were bench trials for these cases, and that we passed that a long time ago. And at summary judgment, I had thought the standard a plaintiff needed to meet was just whether there was a material dispute of fact about question of discrimination on an individual basis.
Correct.
But the McDonnell-Douglas framework has 3 steps, none of which appear in summary judgment or in the statute. And the third step has really caught up a lot of plaintiffs, right? Having to show that the defendant's stated reasons for the adverse employment action are pretextual.
Right.
Right. Okay. And that's okay. So yeah, that's the part. You have to have something to hold on to as far as a decision point of choosing someone over someone else on the basis of some protected, or let's say you can extrapolate from written law attribute.
It could be that they are not pretextual, but there's still discrimination.
Correct.
2 causes, right? And normally we would think Title VII would capture any but-for cause.
Correct.
And so just thoughts about that.
Yeah, I don't want to step on the petitioners or the respondents in the Hiddle case at all in this manner. My personal sense is that the statute is trying to understand, as you say, Justice Gorsuch, it's trying to understand whether discrimination happened. And I think the takeaway from Hicks and Reeves versus Sanderson is that, look, if you have this legitimate non-discriminatory reason, let's not just fight over pretext and whether that happened or this happened. Let's just try to get at the root of the issue, whether discrimination happened. And if I can just maybe tie it back to this case, the question is whether individual discrimination happened. It's not about whether, as the Sixth Circuit put it, there's some pattern or practice of group-based discrimination or some specific look at the status of the decision maker here. I think it's about the individual circumstances in any individual case.
Isn't it about whether the stated reason by the employer was true, or if not, whether it was because of race or sex or what have you?
Well, yeah, and that comes back down to, you have to have evidence that there was some deception there. Like if somebody says, "Oh, you didn't hire me because of my race," and like, "No, we didn't hire you because you're a jerk." Like, okay, prove me wrong. It's like, what do you do? If they say, "Oh, we hired this person because we need some fresh eyes on the thing," or whatever, or we hired this person because we wanted somebody from outside the department who had a different perspective and wouldn't feel beholden to any relationships pre-established in the department. How do you prove that that's not true? Somebody can conjure up any excuse that they want. Well, let's say their root decision point is discrimination. Let's say they're a complete and total racist, right? But they keep that all to themselves. It's a notion that is only in their mind's eye. It's not unconscious bias. Let's say it's absolutely blatant bias, but they never say it out loud. They never put it in an email, nothing. You can suspect all you want, and they can say, "Well, we just decided to go with somebody else," or they seem to have a better fit, or whatever. It's really difficult to prove unless you've got something And apparently pattern doesn't necessarily mean anything. It all depends on all this legalese and stuff. So yeah, how do you prove that their excuse is a lie, or at least is less than half of the decision point or something?
Well, I think Justice Kavanaugh, that goes to, of course, steps 2 and 3, and I think whether it's true or not, I think that this court's precedents, I think, instruct that, look, if it's not true under Reeves, that doesn't necessarily require a finding or required
Right,
verdict.
that doesn't require, but
Right.
often will lead that way. I thought McDonnell Douglas kind of dropped out once the employers stated a reason.
Yes.
And that's
You're-
certainly what the DC Circuit has said. That's, I thought, what this court had suggested in cases like a variety of cases.
Yeah, and Justice Kavanaugh, I think that's right. I think
And the
that's
employer usually states a reason in the answer.
Well, yeah, and let me try to tackle that in 2 ways. I think first, certainly,
We're pretty far afield from the question presented. But
yeah.
keep going.
I want to be sort of mindful of that, but also provide a fulsome response here. The first point to your question is, I think that is a possible takeaway from Akins, and certainly the DC Circuit and Brady did hold that. I think the sort of why I don't necessarily know if that can be resolved in this case, this particular case, is look, our client here, Ms. Ames, lost on step 1, and many other clients lose on step 1. Sometimes you don't get to step 2. It's not often, but sometimes you don't, and that's why I think there's a circuit split over whether there should be an additional requirement at step 1.
So all you want for this case is a really short opinion that says discrimination on the basis of sexual orientation, whether it's because you're gay or because you're straight, is prohibited, and the rules are the same, whichever way that goes.
That's right, Your Honor, and
That's all we need to say, right?
I think that would be something. Well, I think you'd also have to say reverse or vacate and remand. I want to look out for my client here a little bit, but certainly as to the reasoning, yes, I entirely agree. I think that this is a narrow question, and it's a question of, is there an added burden? And if the answer, I think, under McDonnell and under Title VII's text is no, then this goes back to the lower courts to resolve.
Just as a footnote, it's not just whether discrimination was a reason, but was it a motivating fact, correct? Under the statute, there could be a legitimate reason, and as Justice Gorsuch said, but it still could have been based
Certainly,
race or
Justice
sex or
yes,
gender identity.
yes, Justice Sotomayor. I think
Gender identity.
I entirely agree with that. I think that the takeaway from several of these court cases, like the Abercrombie and Fitch case, say, look, it needs to be the motivating factor. So I entirely agree, and I don't think.
Right, like I said before, you could have somebody who is making a decision based on some element of discrimination in their own mind, but if there's a tangible, reasonable excuse given, or at least one that's difficult to say yay, nay, or otherwise, then yeah, it's tougher to say that if that was the basis of the decision all by itself, or in the primary decision point. Yeah, so it's like, well, I hired somebody of equal talent, but really I just hired them because of their race. Right? It's difficult to prove that, and that goes back to the whole affirmative action thing. It's like if you have two people of equal talent, skill, scholarship, or whatever else, but then you choose somebody because, well, their race gives them extra point, right? Like affirmative action explicitly said, race is weighted in your favor. So if you did have a scenario where you had two people who are of equal merit, but then one person got the opening versus somebody else, and it was because of an affirmative action decision, well, then you're acknowledging that ultimately the motivating factor in the decision point in making it was race. Then you're violating Title VI. That's why affirmative action should have gone out the window a long time ago, but thankfully it's finally happened anyway.
This case would implicate that line of precedence.
Thank you, Counsel.
Thank you.
Justice Thomas, anything further? Justice Alito? Justice Kavanaugh?
Okay, so that was the plaintiff, attorney for the plaintiff. Now we get to hear from Ohio talking about how they didn't do anything wrong, I suppose.
Justice Jackson? Thank you, Counsel.
Did Justice Jackson ask anything in this case so far? I don't know that I heard her voice, but I don't know. I'm always curious about her because she's the newest of the justices, as far as I recall, and also one of the more contentious. Her back and forth with Clarence Thomas when it came down to the affirmative action case was immature.
Ms. Robertson?
Mr. Chief Justice, and may it please the court. The Court of Appeals applied a different and more difficult standard to petitioner because it considered her a member of the majority. But Title VII draws no distinctions between plaintiffs based on their race, religion, sex, or other protected characteristic. That alone is reason to vacate the decision below, but the Sixth Circuit's test would have been wrong if applied even-handedly. The court required evidence, reason to suspect an employer usually discriminates against a group, but the statute does not. And it required more evidence to make out a prima facie case than this court has held as necessary, including in McDonnell Douglas itself. That heightened standard risks screening out cases with merit and complicates litigation by focusing on whether to shift a burden of production that Ohio had already met in this case. The court should vacate and remand for the Court of Appeals to apply the proper standards in the first instance, including to consider Ohio's alternative arguments for why summary judgment might still be proper. I welcome the court's questions.
In McDonnell Douglas, Justice Powell, the first, said this may be done in setting out the prima facie case. This may be done by showing, one, that he belongs to a racial minority. What work does that do?
We think that that first prong identifies the protected class to which the plaintiff belongs and therefore focuses the litigation on whether the discrimination occurred on the basis of that protected class.
Protected class. Yeah. So again, this smells of like you can't discriminate against the majority demographic, or discriminating against the majority demographic somehow has a higher burden, or isn't as bad of a deal or something. That's what this smells like. It's like, ultimately the law doesn't say thou shalt not discriminate against the majority population of any particular element here enlisted, right? It doesn't say that. So
we don't think it does the work that the Court of Appeals and the other courts that have adopted the background circumstance thinks it does. Namely, that McDonnell Douglas was predicated on some assumption about the rate at which different groups were discriminated against. The court has told us that the McDonnell Douglas presumption arises because of a different insight about employers, that they act for reasons and will be able to provide reasons. So that if this is the rare employer who can't come forward with any non-discriminatory reason for their action, the reason becomes more likely discriminatory. And that is an insight that holds good regardless of the identity of the plaintiff. Of course, that's not to say that a plaintiff who makes out a prima facie case is necessarily going to trial. In virtually every case, an employer will come forward with some non-discriminatory reason for their actions, and then the question will focus on whether that reason is pretextual or whether there's otherwise evidence to indicate that the employer acted for a discriminatory reason. And that itself is a difficult burden for plaintiffs to meet. We reject the Sixth Circuit's test because it's adding an additional atextual burden at step one that risks screening out cases that might otherwise satisfy the statute standard for liability.
Ms. Robertson, could you give us a little background about the EEOC's interpretation of the statute? Because it has a different approach, right?
No, the EEOC has a different approach than what the Sixth Circuit
Than what the Sixth Circuit. Yeah, sorry, I didn't mean than you do. I meant than the Sixth Circuit.
Yes, the EEOC has rejected the background circumstances rule. It applies the same prima facie case, the one this court articulated in McDonnell Douglas, for all plaintiffs. And it's been consistent with that because it understands this court's subsequent decisions in McDonnell and Burdine and Fernco to reject the idea that McDonnell Douglas turned on the race or identity of the plaintiff.
And, I asked before whether this would lead to a floodgate problem, as the department says, oh, then you're going to have all these people filing suits. The EEOC, am I remembering right, it was like 2001, and it's consistently had this interpretation of the statute? What has the EEOC's experience been?
The EEOC has had this interpretation since 2006. The EEOC, to be clear, while it does investigate all charges, parties don't need the EEOC to conclude that there is reasonable cause to proceed. The EEOC will always issue a right to sue letter. But I will say that in our experience as an employer who regularly litigates these cases as a defendant, we don't need a higher prima facie case to weed out cases without merit. That's because in every case, the government can provide a non-discriminatory reason for its action. And so the case will proceed to step 3, whether or not that reason is a pretext or whether or not we ultimately acted for a discriminatory reason. And that in itself, as I said, is a high hurdle. And so if a plaintiff can't satisfy that bar, they won't go to trial. So we share Ohio's concerns with making sure that meritless cases don't reach trial. We simply think that raising the standard at step 1 would be exactly the wrong way to address that concern, because it would focus parties on a question that has often become ancillary by the time a court considers a motion for summary judgment. Because during discovery, a defendant will often, virtually always, offer some reason for their action, be it through a deposition, through a declaration, some other paper evidence. And so for the court to focus on whether a plaintiff has triggered a burden of production that a defendant has already met strikes us as beside the point. And of course, that's what the court said in Akins and Hicks. That's what the DC Circuit has said. And we think to the extent that there is confusion about McDonnell-Douglas, Justice Gorsuch, it would be helpful for this court to clarify in remanding to the Sixth Circuit that because Ohio has already met its burden of production here, the court can and should proceed to the ultimate question of whether a fact finder could find discrimination.
Yeah.
Well, I was able to find from the Ohio Department of Youth Services. Let me see here, make sure I got this. At least the implications of a DEI philosophy. The DYS recognizes that diversity in the workforce is a source of strength vital to its ability to effectively represent and serve the state of Ohio's increasingly diverse population. We are committed to actively promoting greater diversity in our workforce, including greater racial and ethnic diversity at all levels of the agency. So that doesn't mention orientation, but at least by, again, I will admit to my own bias after years of reading this kind of stuff and listening to this kind of stuff, that at least implies a philosophy of trying to right the wrongs of the past and disrupt what would be perhaps just reflective of population demographics for the sake of aesthetics and virtue signaling. So that's not evidence of wrongdoing on the part of the Ohio Department of Youth Services. But from the outside, that would make me wonder, well, how much more detailed did this initiative go when making hiring and HR decisions? I don't know. Got to wonder. But again, they seem to be operating without any direct evidence of a decision being made, just the appearance of impropriety and the imbalance of the experience and desire of the individuals that ended up in the jobs, plus the fact that both individuals happen to be homosexual. And again, nobody said anything yet about if the employer knew at the time that the orientation of the people involved, both the plaintiff and those that actually ended up getting the jobs, were known to the employer. You'd have to at least be able to show that first, wouldn't you? If you're going to get even to the possibility of there being a consideration of their orientation. I don't know. That seems like at least one piece of information you'd kind of have to have just to reach even the suspicion point.
So I'm sorry, go ahead.
Go ahead.
Well, but I do want to pick up on that point, Ms. Robertson, that at least in many circuits, the step 3 inquiry on pretext has become kind of an absolute condition that has to be met. You have to show that the reason offered by the employer is pretextual to get to trial. And again, we've never held that. This court's never done it in the summary judgment context. I understand other circuits may do it differently, but many have done what I've described, which seems a little inconsistent with, as Justice Sotomayor pointed out, the motivating factor test and with the but-for causation test, where there are two possible causes. One might be non-discriminatory and another might be discriminatory. Any thoughts about that for us?
I'm mindful that the court has before it a pending petition, and so I won't comment on whether what the Ninth Circuit did specifically in that case was incorrect. I will say that we understand that any plaintiff that can produce evidence from which a jury could infer discrimination should go to trial.
Okay, thank you.
Can I ask you about the government's experience in terms of court confusion? I mean, is it your experience that, at least with respect to step one, there's been sort of widespread misunderstanding of what is supposed to happen?
I do think there has been confusion in the courts of appeals, and I think that the court in this case could take two steps that would go a long way towards addressing that confusion. First, it can make clear that the first step of McDonnell Douglas should not screen out any case that might ultimately satisfy the statutory standard for liability. So what the Sixth Circuit did here, for instance, by asking for reason to think that an employer usually discriminates against a group, requires evidence that a plaintiff wouldn't need to establish liability under the statute. Because of course, even if an employer generally treats a group well, if a plaintiff has evidence that the employer discriminated against her, she should be able to proceed.
So I hear you saying that first step is make sure you make clear that step one is a low bar. You're not proving your case at that point.
Yes, I do think that is an important point. A plaintiff is not required at step one to prove discrimination is more likely than not. They need to prove at step one that the facts, if left unexplained, would make discrimination more likely than not. And that lack of explanation itself does significant work. Because if an employer cannot come up with a non-discriminatory reason, any reason, even an arbitrary reason for why it took the employment action it took, that in itself is highly probative of whether or not there was discrimination. And the additional facts necessary to prove discrimination in that circumstance would be, as this court has said, quite minimal.
And I apologize.
Okay, maybe I missed it in all of this. What reasons outside of discrimination, obviously, did? Oh, my alarm's going off. Pardon me. Cheerful but annoying. That alarm. Okay. Anyway, what was I saying? Oh yeah. What reasons did the Ohio Department give for hiring these two individuals who didn't apply for the job, weren't interviewed for the job, and both had far less experience than those who had applied? What did they say their reason was? Has that been stated yet? Maybe I missed it somewhere. Or do they even ever give a reason?
Just for cutting you off, there were two things the court could say.
The second one I hit on earlier, and Justice Kavanaugh asked about as well, which is clarifying that if an employer has met its burden of production, whether that employer had the burden in the first place is not something that the court need answer. And
are you guys seeing ads? YouTube has been dropping ads in the live streams now, and frequently my tabs crash. I have not monetized this stream. I might do so after it's completed. But yeah, I've been hearing complaints. There's been a couple times now where I've monetized a live stream before I've started it, and then people complained about ads dropping in the middle of it, which I would find ridiculously annoying. So I've stopped doing that. If I monetize something, especially a live stream, it'll be after it's already been posted. So it's not a live event that somebody's getting interrupted at. So if you're seeing ads, not because I monetize it. That if YouTube's putting ads into this thing right now, not my doing. And yeah, I sure as heck better be getting paid if they are. Yeah, so that's my policy now. So like for a DEI Death Watch stream or something else, I'll not monetize it till after I've already completed the stream and it becomes a recorded event rather than a live event. Because yeah, I can completely understand getting interrupted in the middle of something happening or being said or whatever, and then missing out and having to listen to an ad for 5 seconds or whatever it is. So just for future reference. If you're seeing ads during an actual live broadcast, ain't me doing it.
Instead, the court can focus on the ultimate question of whether there was discrimination, including, of course, considering any evidence that suggests that the reason that the employer gave was pretextual.
But of course, that would be going on to talk about step 2 in a way that really is a little bit outside the scope of this case, right?
We simply think that in remanding to the Sixth Circuit, because Ohio on these facts the Court of Appeals has already held, has satisfied its step 2 burden, it would be appropriate for the court to say that the Court of Appeals can proceed directly to step 3.
Thank you.
Would it be the rule that the Sixth Circuit applied was apparently based on an intuition about the way in which most employers behave, and maybe it was sound at the time when McDonnell Douglas was decided. Maybe, as some of the amici have argued, it's no longer sound today. And suppose we say that that was an error. Would it be permissible for a court to transport that same notion into the subsequent steps of the McDonnell Douglas inquiry? In other words, in taking into account whether there's sufficient evidence to get by summary judgment, can a court take into account the race of the decision maker and the race of the plaintiff?
I think it's important to distinguish between 2 ways that a court might take race into account. The first is the way that the Sixth Circuit did, which is tell me your race and I will tell you how much evidence you need to produce, or I'll apply in a different standard. That would be wrong at any stage in the proceeding.
Okay.
That's not to say that race is irrelevant in a race discrimination case or that sex is irrelevant in a sex discrimination case. And I think it's helpful to understand how that type of evidence comes in practice. In our experience litigating these cases, it typically takes 2 forms. First, a plaintiff can introduce evidence that their employer has a history of discriminating against their particular group, be it a discriminatory pattern of hiring or firing.
Demographic. I keep saying group. I know it's I'm nitpicking. Demographic. I know.
Or a history of derogatory comments directed at a particular group. Second, courts can consider a plaintiff's identity to help them draw inferences from the evidence in the record. So comments that look neutral in a vacuum might take on a different valence.
Microaggressions.
When directed at a certain group. And just to give you an example of what that means, in Price Waterhouse, this court had no trouble understanding that when a male supervisor tells a female subordinate that her chances at promotion would be better if she wore makeup, wore jewelry, was less aggressive, that comment invokes sex stereotypes. Whereas if an employer told a female subordinate, meet your deadlines, common sense would tell us that's not sex-based, absent some other evidence to suggest it is, like the
microaggressions.
The employer doesn't enforce deadlines for male colleagues. So of course, the court can consider that type of context and common sense inferences. What a court can't do is what the Sixth Circuit did here, which is draw inferences solely from the identity of the plaintiff and the court's own judgment, independent of any evidence in the record about how frequently that group may or may not experience discrimination.
Okay, so what I'm gathering here, again, I'm not an expert on the case prior to it reaching the Supreme Court, is that save for the appearance of discrimination, save for the appearance of impropriety, they don't have any active evidence, comments, emails, other things going on. It's just that this lady applied for a job. The job was not filled by her. It stayed open for a while, and then it was given to a homosexual, not even applicant, but just another employee. The person didn't even apply or interview for the job. And then her own job, she was taken out of and replaced by someone in the same demographic split. And so it seemed like a pattern to her. Again, is there anything to say that the employer knew the orientation of all involved as the decision point? Possibly. Just that they'd have to at least, you'd have to at least be able to show they had the possession of that knowledge in some way to jump that gap, I would think.
Thank you, counsel. Is a protected characteristic on the part of the decision maker alone enough to establish a prima facie case?
No, we don't think so, Chief Justice. And that hits at an oddity about the Sixth Circuit's opinion, is that it suggests that evidence that wouldn't be enough to make out a prima facie case suddenly would be if you change the identity of the decision maker. But because the prima facie case is hitched to step 2 and looks to what would happen if an employer couldn't come forward with any explanation, we think that whether or not the decision maker was of a particular identity or not, if they can't come up with any non-discriminatory reason for their actions, that alone is a strong signal of discrimination.
Okay. The identity of the decision maker. Okay. If someone is working to virtue signal, then their identity is functionally irrelevant. Right? I mean, if you have someone at the top who is a total beta DEI zealot who happens to be a straight white man who's trying to make penance for the very nature of what he is, and he's making hiring decisions in order to show off how virtuous he is and how virtuous his department is and make everything look good, his particular elements in then favoring other demographics for the sake of virtue and not on the basis of merit, that's irrelevant. It's like, oh, well, I mean, you can't call this person racist in their hiring decisions because, well, the decision maker is black and the people they hired are white. So obviously there can't be any racism there. That doesn't necessarily follow. Of course, again, you'd have to have something else, some other indicator, or at least some other element that shows motivation than just supposition. But again, I don't know exactly what I'm arguing here, in the sense that I don't understand all the legalese of what they're arguing either. But to focus on, oh, well, if the decision maker's identity or immutable aspects are this, then any decision they make on the opposite side for someone else obviously can't be motivated by discrimination. That doesn't make any sense to me necessarily either. You still have to show something about it. Now, I mean, if you had someone who was, let's say, a particular race or orientation or religion, and the only people they ever hired matched one or more of those elements, then you could say something. But to say that there's no evidence if the employer is straight and the people that they hire are gay, that doesn't, I think that's what they're saying here, and that doesn't necessarily track to me.
Thank you. Justice Thomas? Justice Alito?
Well, I want to follow up on the point that you were answering previously. So I do think it's an important point. When you say that some of what the Sixth Circuit appeared to be concerned about can be considered at a later stage of the McDonnell-Douglas process, that does not mean that the stereotypes based solely on the decision maker's race and the plaintiff's race are permissible.
That's right. The court always needs to look at the evidence in the record before them. And we think that when the court is confronted with particular facts about a particular employer, of course, that's appropriate to consider. And the fact that a plaintiff was a member of a group that this employer has historically discriminated against, of course, can be relevant. And we wouldn't want the court to suggest otherwise in an opinion. Likewise, as we said in note 1 of our brief, this case doesn't have to do with the prima facie case in a pattern or practice case, where, of course, whether the employer usually discriminates is exactly the point. But the court should not, based on its own independent sense of which group experiences more discrimination or not, draw its own conclusions absent.
Okay, so this is not a pattern and practice case. And yet you say that it would be permissible for a court at a later stage of the McDonnell-Douglas process to take into account the employer's hiring patterns. Yeah, so what would that mean here? Suppose that the plaintiff said, look, they discriminated against me because I'm heterosexual, and here are 5 other instances where they did the same thing. Is that going to come in? Is the court going to have mini trials or mini summary judgment proceedings on all of these other alleged instances?
I think there are two types of historical evidence about an employer's hiring or firing patterns that might come in. The first is statistical evidence of the sort that the court in McDonnell Douglas said may be relevant at step 3 of the litigation. The second is any comparator evidence. So if a plaintiff can point to 5 similarly situated individuals of a different protected group that the employer treated differently, that would be relevant.
Justice Sotomayor? Okay. Justice Jackson? Okay. Thank you, counsel. Mr. Geiser?
Mr. Chief Justice, and may it please the court, Ohio agrees it is wrong to hold some litigants to a higher standard because of their protected characteristics. But that is not what happened in this case. When Governor DeWine took office in January 2019 and appointed a new cabinet-level director of the Ohio Department of Youth Services, the state's juvenile correction system, petitioner was an unclassified civil servant, effectively an at-will political appointee. She claims the department took 2 adverse actions against her in the first 5 months of the administration, denying her a promotion and demoting her because of her sexual orientation. But after discovery, she could not establish that anybody was motivated by sexual orientation or even knew her sexual orientation, nor the orientation of the unclassified political appointees, Ms. Frierson and Mr. Stoj-Sevljevic, that she points to as comparators.
Aha. Okay. Well, granted that they don't have counter evidence, and I suppose at this stage in the litigation, they would have to have shown that. Okay. So taking that on its face, there's been no evidence presented that the decision maker, the employer, had any foreknowledge of the orientation of anybody involved. Now, does that mean something unfair didn't happen? No. But does that mean that it's something that you can activate on the basis of Title VII or something? Not necessarily either. It could be simple nepotism, cronyism, or something else, which isn't good, right? That doesn't make it somehow better or something than rampant discrimination elsewise. But it's also a lot harder, and it's a steeper hill to climb to prove that something illegal has occurred necessarily. Somebody can make a stupid hiring decision, and it's just a stupid decision that wasn't motivated by malice, discrimination, or anything else in any sort of mean-spirited way. It could have just been a bad decision. Of course, I guess it would depend on the performance reviews of the individuals they hired, but that's beside the point. So if what our lawyer for the state is saying is true, then yeah, this is a tough case. How do you show that they were hired or the decision point was orientation without something else, right? At least a proof of possessed knowledge or proof of some kind of statement by the decision maker that, some diversity and inclusion statement or mission statement or something or otherwise that would at least indicate a motivation. Yeah.
In other words, she failed to make out a prima facie case under the first step of McDonnell Douglas that should apply to every Title VII plaintiff. She didn't provide evidence that, to quote Fernco, if otherwise unexplained, raises an inference of discrimination. Mm-hmm. Whether that evidentiary standard is framed as background circumstances, as in Parker, or circumstances which give rise to an inference of unlawful discrimination, as in Burdine, this court has said a prima facie case under Title VII must be complete enough for the court to enter judgment for the plaintiff before the burden shifts to the employer. Because the best reading of the Sixth Circuit judgment applies that standard, this court should affirm. If this court nevertheless holds petitioner made out a prima facie case on these facts, then McDonnell Douglas has effectively 2 prongs, and the court will have made Title VII that unusual statute that presumes liability for employers and swallows what remains of at-will employment. I welcome the court's questions.
Do you think the Sixth Circuit's opinion is consistent with your argument here?
I think, Justice Thomas, that's the best way to read what the Sixth Circuit was doing. My friends on the other side have language they can point to about additional or higher burden that we think this per curiam shouldn't be scrutinized on that level.
But it does say that if the petitioner were of a minority, a different group, that the additional burden would not be necessary. So how's that consistent with your argument?
Well, I think that what the court was doing was saying just going through the four elements that what McDonald calls the sample pattern of proof wasn't enough in this particular case because there wasn't any evidence that raised an inference of discrimination merely from those bare four facts.
So do you think the concurrence got it wrong too?
Well, with great respect for Judge Kethledge, we think that he latched on to what Ms. Ames had said about the relative qualifications. And so Ohio sees it differently from Judge Kethledge.
How? Again, if they haven't already said it, maybe I missed it somewhere in here. What was the department's stated justification, if any, for why they hired those two individuals rather than the plaintiff? Or there was mentioning that other people within the department that were of similar experience level as the plaintiff also applied for these jobs, but was denied them. What was their explanation, if any, given? Even if it's BS, if you can prove it, I'd still like to hear what it is.
You guys you can say, well, there's language. I think that's the absolutely critical language in this opinion. Because Ames is heterosexual, she must make a showing in addition to the usual ones for establishing a prima facie case.
Because she's in the majority demographic? So is there a greater burden on the majority demographic to show discrimination? Is that what I'm hearing? I think that's what I'm hearing.
And then it says, Ames's prima facie case would have been easy to make had she belonged to the relevant minority group here.
Right. Okay. So, quote unquote, reverse discrimination is harder to prove than actual discrimination. Except that, and again, I don't know if there was any active evidence that Ohio was doing something like quotas or whatever. But to have your head in the sand in this day and age and in the zeitgeist that is DEI and elsewise, and the racial reckoning after George Floyd and all of the movements to try to right the wrongs of the past, to somehow now believe that a adverse action taken against an individual who happens to fall in all or in part into majority demographics, therefore cannot be the victim of discrimination or illegal discrimination, is utter nonsense. Utter and absolute nonsense. Anybody who has listened to DEI advocates or consultants over the last 10 years, and time and time and time again, you'll see these guys point to, well, here's a photograph of this company's executive team. It's all white guys. So obviously there's no diversity there. Right? It's nonsense. That's silly. I'm not saying that necessarily that's what happened in this case. I don't know. And so far I haven't heard anything you could actively say, aha, there's where Ohio, the Department of Youth Services made a decision based on the orientation of the individuals. But to say that somehow can't happen or isn't a viable argument to be made in a discrimination case because the subject claiming victimhood is part of the majority demographic in some way, shape, or form is ridiculous to me. That does not suddenly veto or dismiss out any claim of having been discriminated against. If you've been listening to what's been going on in the world for the last 10 years, and, I have.
They're gay people. So, this is what the court did.
Well, and we can't retreat from what the court here said, but we think the best way to construe that language is consistent. But nevertheless, I think
the best way to construe that language is as the language says.
Well, Justice Kagan, yes, the court said what it said. The important point is the prima facie step this court has laid out needs to be complete enough before the employer has any burden under Title VII to show an inference of discrimination.
You agree that those passages are wrong?
We're not defending the exact language there. This per curiam, we asked for
the exact language, or you're defending something like that language? It's a little bit of a peculiar situation, isn't it? Because this is what the court said, and you're up here, and I don't know exactly what to make of this. Do you think that that's right, or do you think that it's wrong?
I think the idea that you hold people to different standards because of their protected characteristics is wrong. And if there's any upshot from this case, let reverse discrimination completely fall out of the federal reporter.
So you agree with petitioner and the Solicitor General
On that major premise point, but we don't
which
think,
is the question presented.
well, we think that the question presented here is what must a plaintiff do to show at the prima facie step that there's an inference of discrimination? And we don't think Ms. Ames did that. And we think that saying that what the United States says, that just eliminating the two most common reasons.
That
and
could
then
be all sorted out on remand, right? I mean, all we have before us is really what Justice Kagan was reading, I thought.
Okay, so if I'm understanding the guy, he as well does not believe in the reverse discrimination argument, but he's saying that in this case, the plaintiff simply didn't show any evidence to lead to a conclusion that discrimination took place. And that's effectively, so far, what I've heard, that's effectively where I'm kind of landing on this, is that any idea that somehow she has a weaker case simply because she's heterosexual, I think is nonsense, right? Either you've been discriminated against or you haven't. It doesn't matter where you fit into the population demographics. So yeah, the whole reverse discrimination can't happen thing or whatever, BS. And again, there's no such thing as reverse discrimination or reverse racism or that stuff. There's just discrimination and racism. Doesn't matter. I mean, someone thinking that they're rebelling against the majority, they're going to be an activist to try to change, put right what once went wrong. That's as much discrimination as someone keeping, quote unquote, the status quo, if that's their motivation. So reverse discrimination, BS. Is there anything substantive? Oh my gosh. I had the word coming out of my mouth before I realized what I was saying. Is there anything substantive to at least imply that the reason that these individuals were hired was because primarily on the basis of their orientation as opposed to the orientation of the plaintiff? You got to have something else than just the appearance of impropriety. That might be the first step to ask more questions and look for more information. But so far, both from the plaintiff's attorney and, likewise in contrast by the defendant's attorney, I'm not hearing that there's anything more than just it looks fishy, right? Yeah.
Well, our argument is that this court reviews judgments and the judgment was correct. I think that everyone here agrees that everyone should be treated equally.
All right, so what is that treatment? What must a plaintiff do in your view?
So under Reeves, this court said, provide enough evidence that there's an inference of discrimination. This is also footnote 7 of Burdine, legally mandatory presumption of discrimination. And then the court said
do we not have the steps anymore within that he was a member of a protected class, that he suffered an adverse employment action, that he was qualified and was replaced by someone else? Is that not how you conceive of this, as like the statement? You seem to be suggesting that evidence has to come in at this very first stage, and you have to really establish that you have been discriminated against. And I had not understood the first stage to be that onerous.
Well, we don't think it's onerous, but this is its summary judgment. This is after complete discovery, document production. Here, I think we had 6 depositions under oath. If you can't show any evidence that the employer was motivated by a protected characteristic when they took the adverse action, and certainly if you can't show an adverse action at all, that's not enough to create any burden of production for the employer. And that sample pattern of proof, the 4 elements that McDonnell Douglas lays out, courts have adapted that under this court's guidance. So in Swearkiewicz versus Surima, this court said, before discovery has unearthed relevant facts and evidence, it may be difficult to define the precise formulation of the required prima facie case in a particular case. And so what those 4 elements happen to be, this court has directed lower courts to never treat them as an exclusive or...
I understand, but I guess, what's happening is that we have a burden shifting test that we have indicated on several occasions is sort of graduated in terms of how you get to the ultimate question. And I thought that what was necessary to shift the burden to the employer to come up with the reason or explain what was not supposed to be all the evidence that you have related to discrimination, that it was just enough that you say things or have enough evidence that establish an inference, that you could more likely than not, and then the burden shifts and the employer really has to explain what's going on here.
Okay, fair enough. So I'm like our plaintiff. So circumstances are she's a 20-year career professional in this department. There's a more superior job opening up that she is likely qualified for. Applies for it. Several others apply for it. The job stays open for a long time. And then all of a sudden, that job is filled by somebody who has far less experience, did not interview, did not apply for the job. And then she herself has her own job. She's fired from her own job, removed from her own job, and then had someone replace her who is in the same orientation demographic as the person who took the job she was going for. It is suspicious. It's a little weird. I haven't heard yet what the employer, the Department of Youth Services, what their reasons given for putting the person in the superior job in the first place and then replacing her with someone else who is also less qualified, but also within that same orientation demographic. Like, what? I'm gonna have to look into this case and see if I can find it somewhere in an article or otherwise. What did the Department of Youth Services say was their justification or rationale for making these decisions in the first place? I don't know if they're BS or not, but what did they say their logic was?
Well, I agree with your characterization, Justice Jackson, and that's what this court said in Reeves, where the court made clear that if you have enough evidence at the prima facie stage that you could, looking alone at that, grant judgment for the plaintiff, then the employer has a burden.
So what was the
Mr.
failing? Oh, sorry, go ahead.
I just wanted to clarify what you were saying to Justice Kagan and Justice Kavanaugh. Do you agree that if the law in the Sixth Circuit is, as Judge Kethledge's opinion describes it, that it's wrong?
I think that if that were an accurate characterization, yes.
So this whole dispute then is really just about how we interpret what the Sixth Circuit said?
No, I don't think that's alone what's at issue, Justice Barrett. I think, the case that we cite, I think, is a better description. This per curiam opinion, we asked the department for oral argument, and my friends on the other side, too, asked for oral argument. The court just came out with this decision 2 weeks or 2 months after the.
So it might have been sloppy, maybe it wasn't stated well, but you agree that if it means what it says, what Justice Kagan read to you, or if Judge Kethledge's understanding was correct, you agree that that's wrong? We agree. Ohio agrees that it's wrong to treat people differently. So if we said someone like Miss Ames, who is a member, it doesn't matter if she was gay or whether she was straight, she would have the exact same burden and be treated the exact same way under Title VII if she sued as someone who was gay and argued that they were discriminated against under Title VII. Same.
I think that she should have the same burden, and that the best reading of what the Sixth Circuit
Well, no.
did.
I'm just asking you what you think of the statute. So that is what you think of the statute, and same for someone who brings a race discrimination, someone who brings, a woman or a man who brings a sex discrimination suit on the basis of a discrimination against the basis of sex. All of those, you agree that the court should apply the exact same burden, treat them the exact same way.
We agree with that,
Okay,
Justice
thank
Barrett. The only thing I would add is it can't simply be the tick through the mechanical rubric and then the employer has the burden to disprove liability under Title VII. That's inconsistent with the text of Title VII. And we think what this court said, I would point the court to page 3 of my friend's reply brief. They cite this per curiam, this unpublished decision from the Third Circuit that really re-articulates what the United States says at page 20 of their brief. And what they say at the top of page 20 is that the fourth element of the prima facie case should just be circumstances which give rise to an inference of discrimination.
And this is why I think cases similar to this but against entities that have made a blatant advertisement of their DEI policies and or have put forward diversity reports or metrics based on demographic as proof of their progress or something. I think that's in those cases are going to have those employers are going to have a much more difficult time dodging these questions than, say, in this instance, where apparently they don't have anything that says explicitly about orientation. They don't have anything explicitly otherwise stated or written by the employer that indicated that there was this was a decision point for them. Let's say in the case of Facebook, or now Meta, you go back to their 2019 diversity report. I did a video on this back then, looking at it, and they were talking about, we've come a long way in our efforts to diversify our workforce. We have a long way to go. And then you have an entire promotional video created by the company featuring executives within the company citing only demographic metrics from 1 year to the next, or from 2 years previous to current at that point, to show their progress. And no other elements. It's just, how many women do we have in tech jobs? How many Asian Americans do we have in leadership roles? What is our overall Black workforce versus our in tech Black work? Everything was a demographic. Everything was a race, a gender, or ethnicity. And so someone coming in with a case like this one, but let's say the employer is Facebook, I think they'd have an easier time, not necessarily guaranteed because of all the, ins, outs, and otherwise. They'd have an easier time making a case of, well, hey, the company said in public, in their own promotional material, that their goals in hiring were fueled and motivated by race, by gender, in these specific areas, in these specific roles. So this case might, so far, it doesn't sound like they're going to do very well with the Supreme Court, because it doesn't feel like the plaintiff has crossed that extra step of not just the appearance of impropriety, but there being something, I won't say it again, something evidentiary beyond simple supposition that there's a problem. It again, just it not looking good. The circumstances of the hiring, firing, promotion, otherwise not looking good is not enough to cross that legal barrier unless there's some other element. There's something else there. It sounds like the court is probably not going to side with the plaintiff on this. So that's the sense that I'm getting. We only got a few minutes left in this, so let's finish it up.
If that's the rubric that this court says it should apply in every case, then I think Ms. Ames hasn't made out a prima facie
So you're
case.
not worried about, you are not concerned, you're on the same page as your friends on the other side when it comes to the central question of how we should interpret Title VII. Your concern is that we'll say something more about what kind of evidence any plaintiff has to show, no matter what group they belong to.
Yes.
But if we didn't say that, you would be satisfied with an opinion that just said everyone's treated the same under Title VII.
Well, I think that courts could be misled by hearing that basically the prima facie case, as the National Employment Lawyers Association explicitly asks for, doesn't really play a factor in McDonnell Douglas. McDonnell Douglas is a judicial gloss on the statute that is trying to make it easier for plaintiffs, but it's not such that the burden is always and everywhere on the regulated party. The Title VII standard still requires the plaintiff to make out the burden of proof.
Yeah. I mean, you can't just say, oh, I was discriminated against. This is, reminds me of the Kimberly Crenshaw intersectionality argument. All right. Now, as I understand it, I'm reaching back here a little bit. The situation was you had an employer, or I should say you had an employee or a potential employee, I forget what it was, who was a Black woman. And the employer had a demonstrated record of hiring people from multiple races and both genders in different jobs and things. But the argument from the plaintiff in that case was, well, yes, the employer does hire black people and the employer does hire women, but they don't hire a whole lot of black women. So now I've created this class within a class kind of thing, element of discrimination where all of the white women are put into secretarial jobs and all of the black men are put into labor jobs, but ne'er the twain shall meet, and therefore I've been discriminated against. You gotta show something beyond just supposition. There has to be something more active there, right? And especially if there's a pattern to belie that claim from the behavior of the employer in the first place, that's a tougher hill to climb. You can't just cry discrimination because something looks off from a certain point of view without something more to say that it actually occurred, right? And so that's what we have in this case. It's like, yeah, it does look awfully sketchy. Why would they hire people of less experience? I mean, just take it different levels. Hiring two people of demonstrably less experience to fill both a supervisory job and the lady's current job, that seems kind of goofy. But on top of that, that both individuals related to this lady and the job that she applied for and the job that she held are both gay or homosexual. I don't know which one, the gay lesbian, is also kind of like, is that a coincidence? It could be. That's the thing. You got to show something beyond just a coincidence. It might look suspicious, but looking suspicious isn't enough. That might be, as they said, that might be the starting point. You could start off by saying, boy, howdy, this looks awfully weird, guys. How do you justify this? And then how does the employer justify this? I'm curious to see. I'm going to have to look it up because as far as I can tell, it's not being mentioned here. What did the department say was their justification for hiring these individuals over the plaintiff? If they gave one at all, I don't even know.
Why is it so hard on an employer to just say why they didn't hire someone?
Well,
I mean, you're making it sound as if by making out a prima facie case, it's unfair to the employer to say, you didn't hire them, explain why.
well, two responses.
They don't have to prove the why.
Yeah, two responses to that, Justice Sotomayor. Number one, the text of the statute allocates the burden not to disprove liability, but to prove liability. And so the prima facie case needs to be a complete case enough at that circumstantial stage before the employer has a burden under the text. And then secondly, doctrine. This court has said that case needs to be enough to create a legally mandatory inference of discrimination.
But you seem to be putting this on its head. You seem to be saying that they have to be able to win the case on the prima facie evidence. That's what you're suggesting.
If unanswered.
Judge Ketledge basically said, you have a situation here where she alleged she was a member of the majority group. She was 20-year employee, great reviews, and then all of a sudden she's not hired, and someone's hired who's gay, doesn't have her level of college experience, and didn't even want the job. It's something suspicious about that. It certainly can give rise to an inference of discrimination. Now, whether those facts are enough to make out that the employer's proffered reason is pretextual or pretextual in some way, the court hasn't gotten to that yet.
Well, so Justice Sotomayor, I think the really crucial fact here is every circuit, and we point this out in our bio, every circuit has said that if the employer isn't even aware of the protected trait, it's not possible to infer that they were motivated by that protected trait. And that doesn't come in at prong 2 of the McDonnell-Douglas burden shifting. You don't have to disprove the negative. It's the burden on the plaintiff at a very minimum to say, they knew about your protected characteristic. And what the evidence here showed was that no one knew Ames or Frierson's sexual orientation. The petition appendix at 32A, the district court made a factual finding that has not been appealed here, that no one knew Ms. Ames' sexual orientation at the time of the relevant employment decisions.
And okay, that's what I've been asking since the beginning. Was there any evidence that anybody knew orientation? to even make that a viable argument for discrimination. So, yeah, if no one's offered even that much, then that makes it a much steeper climb.
And Director Geese testified that he did not know Mr. Stojcevelek was gay, even though others may have suggested that in the record to other people. And that's at JA 46 and 48.
General, I guess my reaction to a lot of what you're saying is this. You say you agree with your friends on the question that we took this case to decide. The question presented is whether a majority group plaintiff has to show something more than a minority group plaintiff. Here, whether a straight person has to show more than a gay person. Everybody over here says no. You say no too. That was the question that we took the case to decide. And now you're asking us to opine on various other aspects of how the McDonnell-Douglas test works, what we should think of the first step as doing, then what we should think of the second and third steps as doing, that are, really not intertwined at all with that question. Whatever McDonnell-Douglas does, it does for majority group plaintiffs and minority group plaintiffs alike, is all that we have to say. Why shouldn't we approach the case in that way?
Okay, well, that is an important distinction. That's something that I whatever else might come out of this case, that does end up being clarified for future lawsuits, is that somehow you are not in a greater burden of evidence situation just because whatever element you're arguing has been discriminated against, you happen to fall into the demographic majority. That somehow you have a greater burden of evidence to prove that you've been discriminated against because you just happen to be not in a minority class. Because Title VII should apply across the board regardless. I mean, that's even in the text. It doesn't say, like, again, you shall only be able to claim discrimination if you are from a minority demographic. It doesn't say that. It's as far as I understood, it should never have come down to that. But if the ultimate silver lining of this case, whether the plaintiff proves that she was discriminated against or not, if there's a clarification in law that being white doesn't mean you can't claim racism, then that's probably a good thing. And again, that is going to help cases involving DEI going forward, because the whole diversity argument is falling apart very quickly with these decisions. In affirmative action, what happened there was simply stating that the benefits of diversity outweigh the violations of Title VI and the 14th Amendment fell by the wayside. And the arguments made by the lawyers in that case were the exact same justifications, the exact same virtue signaling that DEI programs have been making since at least I've been covering it. I remember when I listened to the oral arguments for the affirmative action case, I remember it was so clear to me. I was sitting at my desk at work and I had little earphones and I was doing my work and everything and listening to the oral arguments. And the attorneys for the colleges stood up and started talking and giving their argument for why affirmative action is necessary and so on. And I had, to that point, been listening to DEI rhetoric for years. And what they were saying was a carbon copy of what I'd heard DEI executives and consultants say in defense of why DEI is important and why DEI has to happen and why it needs to be the air that we breathe and all this other stuff. Exactly the same. And so when the court ruled against affirmative action, they were also ruling against diversity as a justification in and of itself for sidestepping Title VI. And by extension, as far as I'm concerned, if it ever comes to that, Title VII. Now here, this adds another sort of brick to the wall, so to speak, in that trying to right the wrongs of the past, or that, a decision in hiring or employment that goes against someone that's in a majority demographic isn't equally a violation, or conceivably equally in violation if more evidence is presented. That's also another arrow in the quiver against DEI. It's all these incremental little decisions and clarifications in law that are going to help this move forward. So if nothing else that comes out of this case, if the Supreme Court at least affirms that there's no greater burden on someone from a majority demographic to prove discrimination, at least at the front end of things, then good. But as far as the plaintiff winning her case, I don't see that happening here.
Well, I think there are two responses to that, Justice Kagan. First of all, while we all agree that everyone should be treated equally, we don't agree about what that prima facie step actually looks like.
Yes, I
when they
know.
do
That's
that.
exactly what my point is. But that's orthogonal to the question we took. So, I mean, why would we use this case, which is about whether a majority group plaintiff has an extra burden, to opine on a range of things that have nothing to do with that question?
Well, so what the Sixth Circuit did here, this is my second reason, Justice Kagan, if the first one doesn't satisfy you, is exactly what we think every court should do. Ask for enough evidence to raise an inference of discrimination. And simply going through those four prongs, copy-pasting McDonald.
But that's, as you said, that's not the question before the court. Okay, the question before the court is, as I understand it, should someone from a majority demographic have a greater burden in such a case at the front end of things than someone who is in a minority demographic? And everybody's saying the answer is no. Everybody should be treated equally. And that's it. We're done. But now he's trying to take a step forward and talk about things that apparently aren't germane to this question. He's trying to have his cake and eat it too, or something, I guess.
Douglas, with subbing out racial minority for any particular protected group, doesn't do that. It doesn't satisfy what this court said in Reeves and Burdine in footnote 6 and 7. And so our thought is the court should still affirm, because what the Sixth Circuit's judgment did here is what we ask every court to do at the first step of McDonnell Douglas. Even if we agree that saying that an additional burden is a mischaracterization of what this court has said in the past.
Mr. Geiser, I guess maybe another way of coming at perhaps the same question is, what would be wrong with a judgment holding that everybody is treated equally at the first step of McDonnell Douglas if it applies at summary judgment? We've never so held, but let's assume. And that you would then on remand be able to argue about what that fourth prong of the first prong of McDonnell Douglas means for everybody. What's enough circumstances to give rise to an inference of discrimination? We wouldn't say anything that would prohibit you from making these arguments to that court in the first instance. And normally, of course, we are a court of review, not first views. Justice Ginsburg would like to remind us.
Well, Justice Ginsburg was very wise, Justice Gorsuch, and we don't want to make assumptions either way. I think that the court should still affirm. I'm defending the judgment on behalf of my client. But if the court is going to say anything about what that first prong happens to mean.
I'm positing a circumstance where we don't. Affiant saith not anything about what that first prong means, other than to say it applies the same to everybody.
Well, we agree that the court should say that at the very, very minimum. But
we're in radical agreement today on that, it seems to me. The counsel before us seem to be in total agreement. And then, if your argument is, as applied to everybody, she fails on the fourth prong of the first prong of McDonnell Douglas, perhaps a court should take a look at that before we do. What would be wrong with that?
Well, I think there's something in between those two levels of abstraction, Justice Gorsuch. We agree on that first level, and we think that the court can avoid that sort of third level down. But the second level here—
Boy, I'm lost. We have four prongs and three prongs and four levels.
Yeah, geez, I'm getting trying to do a mental map of Metroid here or something listening to this.
Just what's wrong with the opinion I outlined to you?
Well, I think a lot of courts are going to get the misimpression that that first prong of the prima facie case, that McDonnell Douglas step one, if it applies equally to everyone and the court saith nothing further about that, that it just means the burden is on the employer to produce evidence.
No. That doesn't. That's not what it says at all. And I'm not even a legal expert. Like, my immediate reaction before you hear the justices on the bench start going, no. Like, no. These two things are completely separate from one another. Okay. Putting no greater burden on someone on the basis of their demographic fit does not then immediately say something about the burden on the employer. It just, what?
Why?
No, why would that be? We would say, I mean, you as the government points out, you point out, everybody points out, you got to show you're a member of a protected class, 1, 2, who's qualified for the relevant position, 3, was subject to an adverse employment action, and 4, and this seems to be where the dispute is, was taken under circumstances which give rise to an unlawful discrimination. And you say that's not met because the relevant decision makers didn't know the plaintiff's sexual orientation. Interesting argument. Not presented here. Let a lower court pass on it first. Why wouldn't that be a wise course for this court to follow?
I think it would be wise if the court adopted the 4 prongs read just as you read them, Justice Gorsuch. And if the court doesn't want to say anything more about that, we still think the court can affirm. But if the court is going to make sure to say what is at the top of page 20, I think that would be good guidance for this court to give.
I thought this is not what I think we should do, but I'm just going to throw it out there, which if we talk about McDonnell Douglas, I thought once the employer stated a reason, the whole thing kind of drops out. And then as Justice Gorsuch says, you're just figuring out, was it based on the stated reason or was it based on a prohibited characteristic?
Well, I think there are 2 issues with that. Number 1, if you have a case like this one where the employer has good evidence that they didn't even know the relevant protected characteristic, the employer shouldn't have to say, if I want to make that argument, I also have to forego providing a legitimate reason if I want to be able to win on that first fundamental threshold. So under the Brady opinion in the DC Circuit, I think there's a really good argument that McDonnell Douglas no longer applies. This court has already said it in Aiken at trial, and it doesn't apply because this court said it in Surema at motion to dismiss. What does it do in summary judgment? I still think there needs to be room for the employer to proffer a good reason and use that as an alternative grounds for, and the plaintiff didn't even meet their prima facie case. In other words, the employer shouldn't be forced to choose one of those 2 possible
we
litigations.
fired the person because of X, and we didn't even know they were, whatever the characteristic is.
Well, I think,
I mean, I don't know if you calling it prima facie. I'm far afield, but as you're aware, I don't think that's pretty very useful to how to figure out these cases once the employer has stated a reason. So I'll leave it there, though.
Yeah, I think the court should allow employers to be able to make that alternative argument. They didn't make a prima facie case, and we have a good reason, and either is a grounds on which.
Well, I think I agree with that, but they're both arguments for why it wasn't discriminatory. I think that the decision to fire the person was not based on their sexual orientation or their race or what have you. It was based on something else.
Well, I think they both do go to the ultimate question, Justice Kavanaugh. I do think, though, that one is a very negative shield sort of argument and the other is an affirmative sword sort of argument. And the prima facie case is there to capture, was there enough evidence to show a sort of freezing time in place with no answer at all from the employer that Title VII elements could be met, that there could be an inference of discrimination at the first step. And I don't think the court should retreat from any of those statements that it's made from Burdine to Fernco to Reeves.
Okay,
Thank you, counsel. Anything further? No. Thank you. Rebuttal, Mr. Wang?
Thank you, Mr. Chief Justice. I'll be very brief. I just want to conclude, I think, with several members of the court have talked about this theme. And it's actually something that my co-counsel, Mr. Gilbert, and I talked about when entering the court this morning, which is, I think, what this case is all about. And those are the 4 words on the side of this building: equal justice under law, equal justice under law. Now, I know that sometimes we don't fulfill that promise. I understand that. But at the heart of this case, at bottom, all Ms. Ames is asking for is equal justice under law. Not more justice, but certainly not less. And certainly not less because of the color of her skin or because of her sex or because of her religion. We're simply asking for equal justice under law because I think that's what Title VII says, and I think that's consistent with what this court has held in numerous cases, and it's consistent with Congress's intent in passing a civil rights law to protect the civil rights of all Americans.
Thank you, counsel. The case is submitted.
Okay, well, that's it. That's the end of the audio file. Yeah, so, not having textbook knowledge of this case beforehand, listening to these oral arguments. So for the sake of this bringing forth to the court, the question was, is there a greater burden in bringing a case in the first place on someone whose argued element that they've been discriminated against falls within the majority versus the minority in the population? And I would hope, obviously, the answer is no, there is no greater burden, that somehow you have less of a case if you happen to be from someone or from a demographic that is in the majority. If that had not been clarified in the past under law, but this case makes that assured, then I think that does put, as I said earlier, put another arrow in the quiver of potential future cases against companies that have employed DEI practices. Because then a company that blatantly or otherwise states that they are trying to right the wrongs of the past, or that they are trying to, make employment decisions on the basis of favoring underrepresented groups and so on, that puts them right in line, at least as far as evidence for potential discrimination suits, that doesn't make someone who's a straight white male somehow less of a victim of discrimination if they can show that the employer had that intent, which I think if it wasn't already clarified, I guess it should be now, and hopefully it will be. But those are just my thoughts in being insomniatic and not having my brain on right now. But of course, if you guys have anything you'd like to say, leave in the comments below. I'll take a few here while I'm here. Jill Powers, my husband's father was a rocket scientist who worked for Boeing and the government. They lived in Everett, Washington for a while. My grandfather worked for NASA in the Apollo 11 program, going to the moon for the first time, or we're landing on the moon for the first time. And as far as I understand, we still don't know what he did because it was classified. It was, at least at last time that I knew, it was still classified, even decades after the fact. But I've got I got an autographed photo of Deke Slayton, one of the original Mercury 7 astronauts, a friend of my grandfather. He was I got it on my wall over here. Deke Slayton, one of the Mercury 7. Let's see. Scrappy. By the way, I switched to my phone scribe. They are putting ads on your live. Okay. Again, I have not monetized this. If ads are coming up, then it's not me. I don't know if that's now the one thing that I wasn't sure about in doing this is that I assume, I don't know, I assume that when I'm playing audio from the United States Supreme Court posted on the United States Supreme Court's website, that was freely posted for public consumption, that I'm not going to be hitting any kind of copyright or something, or that somehow someone's not going to likewise claim it for content matching or something like that. I would hope not, because this is free and open information from government sources, and this should be public domain as far as I understand it. What? Oh my God. I get all these notifications on my phone, and they all come in at once, and it's annoying. And the worst part is, as much as I'm a big fan of the Shield, and I've got the sort of opening little scream sound from the Shield as my text alert noise, it can sometimes be a little jarring. Anyway, if you're seeing ads, it's not because I did it. So and if you're seeing ads, I sure as heck hope I'm getting the penny or two that they're supposedly earning. Because, yeah. Anyway, my brain has gone sideways, and now I have to go do work stuff. So for those of you that stuck around with me for this, I know it wasn't a very exciting stream. I was doing it more for my own edification, maybe for yours. If you have thoughts on this case or have more information from your own experience that might be relevant, by all means, leave it in the comments below for future reference. Also, if you haven't already, leave a like. If you're not subscribed, subscribe. If you'd like to join the Discord server, well, let me create a link to the Discord server because, I should have done that beforehand. But again, I was waking up at 2 a.m. So link to the Discord server is in the chat now. If you like to click on that, you'll find yourself on the landing channel called Say Hello. And in addition to saying hello, you just have to say the secret word. The secret word will tell me that you're not a bot. Or actually a person, have watched the stream and have thus earned the right, the privilege, and entitlement to join the Discord server. And today's secret word is Title 7. Just say hello, Title 7, and I'll know that you watched the show for this nigh on 2-hour-long stream that I didn't plan on, but here we go. I'm probably going to be taking a nap later. Also, programming note, will be a TED Excellence this evening at 6 p.m. Pacific, 9 p.m. Eastern, where we'll look at the super secret hidden from view Tess Holiday TEDx. As of this recording, this is a super secret, unlisted, hidden from view TEDx. Why? I don't know. I haven't watched it. We'll find out together. I'm sure it'll be interesting. So again, tonight, 6 p.m. Pacific, 9 p.m. Eastern. I'll hopefully remember to put a poll up for the bingo card for tonight's show later this morning after I get some work done, which I'm going to go do now. So everyone, have a good rest of your Thursday. Have a good rest of your week. Hope to see you tonight on TED Excellence, but if not, I'll see you on the next broadcast, whatever that be. Maybe I'll be doing a DEI Death Watch on Friday morning. That's my intent. We'll see if that happens. And otherwise, everyone, I hope you have a good rest of your day. Hope you're all safe and well. If you're not well, please get well soon. And I'll see you on the next one. Take care. Bye-bye.